Welcome back to Legal Threads, where we pull apart the fabric of famous cases and show how the law is stitched together. Today's story is about an 8-year-old boy, a loving aunt, and a $3,000 promissory note that teaches us why not every promise is legally enforceable. This is Dougherty V Salt, decided by the New York Court of Appeals in 1919. Here's what happened. Young Charlie Dougherty was visiting his aunt, Tilly Salt. She adored him. During their visit she said, "I'd like to take care of him now." With the help of his guardian, she filled out a printed promissory note, signed it, and handed it to Charlie. The note said he would receive $3,000 at her death or sooner, and it included the formal phrase, "value received." She told him, "Someday it will be valuable. Don't lose it." When she died, Charlie tried to enforce the note against her estate. The trial court dismissed the case, saying there was no consideration. The Intermediate Appellate Court disagreed, but New York's highest court, with Justice Cardozo writing, reinstated the dismissal. The issue before the court was simple: did the aunt's promise, written in the form of a promissory note, create a binding contract supported by consideration? Justice Cardozo said no. The problem was that the boy gave nothing in exchange. The aunt's words and the guardian's testimony showed she was motivated by affection, not by any bargain. A promise of a future gift, what we call an executory gift, is not consideration. The words "value received" printed on the form couldn't change that reality. So the holding was clear: the note was unenforceable because it was just a gift promise, not a contract. The judgment was reversed, and the complaint was dismissed. Why is this case important? Dougherty v. Salt reminds us that the law draws a sharp line between moral obligations and legal duties. Even a serious promise, written down and signed, isn't enforceable unless it's supported by consideration, some exchange of value, some bargain for detriment or benefit. The case is often paired with Hamer v. Sidway, where an uncle's promise to pay his nephew for refraining from drinking and smoking was enforced. The difference? In Hamer, the nephew gave up legal rights at the uncle's request, a classic example of consideration. In Dougherty, Charlie gave up nothing. And here's the broader question: should courts ever enforce purely donative promises? Some scholars say no, pointing out that such promises are often casual and unrelied upon. Others argue that serious promises of large magnitude should be honored. But the traditional rule still holds: unless backed by consideration or some other legal device, like a trust or a will, donative promises remain outside the reach of contract law. That's the thread of Dougherty v. Salt, a promise of generosity, but not a contract. Thanks for listening to Legal Threads. Remember to like and subscribe for more cases where we unravel the fabric of the law.